Mary Robinson.
Here.
George Valderrama. Right, is there anyone, and I'm not, anyone that's here that I've not called your name? Ms. Abraham asked that if there's anyone who's not heard their name called. Okay. Council, do we have anyone that's ready?
Ready.
Logan?
Michael.
Right, this is cause number CR 2215, CR 2264. Today, let's come on up here with Mr. Bogan here.
And I've been contacting the state. It doesn't look like we're gonna work this case out, and except for Dr. Paul announcements, I think we need to set this on the jury docket.
Okay. Can the state go on the record what the offer is, that it's going to be their best offer, which is the ordinance projected today? Yes, sure. Mr. Bogan, if you know what it is.
My recollection is that Mr. Woodward has said 3 to 4 TBCJ. I don't think you ever pinned down a number.
I think that was correct. I also offered that he could go open to the court on waiving the enhancements of that Friday.
Is there a specific 3 or 4? I think that's going to matter.
I mean, 3, state law 3.
And that's being rejected today, Mr. Bogan.
Yes, Your Honor.
Okay. And have you informed your client that the court will not accept a plea after today?
Yes.
All right, Mr. De La Rosa, the court will place you on the jury selection docket. We're going to begin that on Monday, December 5th. You'll report here to the Van Zandt County Courthouse. You'll meet with my staff. They will check you in. They'll give you a notice of appearance. You'll sign that. And we'll give you a reset date. Mr. Bogan is not going to be required to be here because your case will not be tried that day. You'll be placed on the court's rolling trial docket, which means you'll stay on that list until your case works its way to the top. Once it gets within the top 10, we'll notify Mr. Bogan and you, but you'll need to check in every month, okay?
Yes, sir.
And you'll need to remain, you're going to remain on pretrial release, so you need to check in with Mr. Waddell. Okay. All right, so Mr. Bogan, if you filled that out, jury selection December 5th, then you're free to go into jail.
All right, thanks.
Here, I'm ready. All right, Mr. Bogan.
Keep the old, there's 1, 2, we keep the old ones.
All right, Isaiah Smith, CR 2279, CR 2282, and we're set for pre-trial, Mr. Sorry.
Yes, I talked to the prosecutor today, and I'm sorry, I haven't been here late. I had that little heart issue. Asked for another pre-trial. I think we'll get this thing worked out.
Any objection from the state?
No, Your Honor.
All right, I've been resetting Mr. Nassar. I've got 3 dates in December. I've got December 1st, 13th, or 15th.
Would be wonderful, Judge.
All right, court sets Mr. Smith for an additional pretrial on December 13th. That will be at 9 a.m. And right now we're scheduled, it's always subject to change, but right now we're scheduled to be back over in the Justice of the Peace Precinct 2 courtroom over there. If that changes, we'll notify you.
Thank you so much, Judge.
You ready?
Yes, sir. We're ready on Mr. Hannah, Mr. President.
Aaron Ham, CR 22-216 for pretrial.
We're not gonna have any pre-trial, Judge. Mrs. Curry's made us a good plea offer. There's things we're still negotiating. She's gonna get me the victim affidavit, non-prosecution, which I've not seen. It's going to provide, other than that, they provided everything. She's wanting to locate the victim. I don't think the victim's located by the state. We're going to provide that to them. and then Ms. Curry's gonna talk to her or one of her assistants. So we're still negotiating the process, but I believe this case is gonna get resolved. I'm gonna be here December 1st, and we just asked maybe that resetting, and I will have it.
Okay.
Resolved by then.
All right, court finds there are no contested pretrial motions. Court sets Mr. Ham for docket call on December 1st at 9 a.m. And we should right now be back over in that JP2 courtroom across the street.
Thank you, Judge.
You're welcome. Free to go, Jim. What are you ready?
I got one, that's ready.
Okay.
Approach.
Yes, Mr. Athena. It's in the point, I see. Apparently YouTube not to do whatever ran. Reset you for docket call on Tuesday, January 24th. That will be at 9 a.m. Just plan on coming here. Right now, I'm not sure where this courtroom is going to be on January 24th. So hopefully we'll be back in our courtroom upstairs, but if not, we'll let Mr. White know. We'll let your boss know. Okay,
Thank you.
thank you. Mr. Schmidt, are you ready?
I am your honor, J.C. White.
All right, J.C. White. This is cause number CR 22-298-310. Show that we're set for pre-trial on both cases, Mr. Schmidt.
We are, your honor. And I've explained to my client, I'm out of the office for most of the last month unexpectedly. And I've received discovery. I've not reviewed the videos, only a cursory review of the written discovery. And I apologize, but it's unexpected. I was gonna see if I could get an additional pre-trial day if possible. I don't know if there's any pre-trial motions.
All right, you want to reset to be available on December 15th at all?
Just a moment. Be perfect, Judge.
Great. All right, court sets Mr. J.C. White for pretrial on December 15th. That will be at 9 a.m. And right now, it looks like we'll be back in this courtroom on the 15th. Okay. And Mr. White, have you met with pretrial release and signed any conditions of pretrial release?
Judge, he did just meet with pre-trial release, and we actually had one question to address. There was a condition that he not be in possession of any weapons. My client owns a company and travels, and I'm not sure what to say, but as far as the finances and things like that, he carries in his vehicle for that purpose, because essentially the company is traveling, and so he's not a convicted felon. And we asked the court to consider waiving that condition of laws, because he's legally entitled to have a weapon with him while traveling.
Any position on state? Charged with evading arrest and driving while intoxicated. B, Mr. Lee.
Judge, if I could have a moment.
Sure. Mr. Sherman, what's the nature of the business? Just tell him.
So he does a large precast concrete for various sites. All of those things. As for many years.
The state's not concerned that Mr. White's a violent offender, whatever the court of appeals justified is what the private state.
So there's no criminal history alleging any allegations of violence.
No, Your Honor.
All right, court will modify the conditions of pretrial release, lifting the weapon prohibition.
Thank you.
And I'll have to fill out new conditions and have Mr. White sign those. So we'll have to have a seat and we'll have to go through that process.
Yes, sir. So Mr. Waddell had all the conditions. I don't know. Just mark that out or do a fresh one or how do you?
Probably a freshman.
Okay. Very good. I'll let Mr.
That
Waddell.
way there's no confusion if someone
Yes, sir. Very good.
looks at it later. You'll speak with Ms. Cagram, she may be able to prepare those.
Oh, I see. There. Got it. Okay, I will, Your Honor. May we step out? And
Yes, And then once you sign those and give them to Ms. Abraham, Mr. Waddell, agree.
Thank you.
You're welcome.
Happy to choose, Your Honor. That's all I
Yes,
have.
sir. Yes,
Thank
sir.
you.
Good to see you. Just one moment, Mr. Donovan. All right, cause number CR 22-205. State versus Kalin, David Cheatham for pretrial. Go ahead, Mr. Donovan.
I think of discovery this morning, I spoke to the state, an offer was relayed to me, which I related to my client, it's a starting place, I doubt this case will end up as a trial. So we just requested a pre-trial this time.
So I'm just gonna raise a concern that I have. So I see that the defendant filed a waiver of arraignment on September 20th. And we set it for today. And I accept the waivers of arraignment and I usually set them off 30 to 45 days to give the state and the defense an opportunity to start working on the case. I get concerned when I hear, Mr. Bowman, you said you picked up discovery today. So that was 2 months ago. I waived his arraignment, so he didn't have to be here. And there was nothing that's happened in 2 months. That's concerning to me. And that's going to prolong this case. It's going to prolong the number of times that the client has to come here. Is there any reason that we haven't started engaging in discovery and talking with the state? They're 2 months after he was. It's more than 2 months after he was indicted. He was indicted in August. No, I'm sorry, he was indicted in June. And I know he had to hire an attorney that was in August. So I just got a concern that. I just feel like I'm setting these things off to give the state and the defense time to work on the cases. And that's not being taken advantage of. I feel like it's the other way. I feel like I come in and I find out that I've waited 60 days and I'm just hearing. I'm gonna go pick it up today, or I just picked it up this morning. I need another 30 days. I need another 60 days. Can you address that for me?
Absolutely, Your Honor. And that's entirely on me. I have been, I've had several cases that have been drawing my attention that have been trial cases, and I haven't made it down to Canton in a couple months, I believe, the last time I was down, but I'm not sure if the schedule was ready or not, but that is on me, and I get the court my apologies.
And you're not the only one, Mr. Donovan. It's just become a recurring. It's become a recurring theme. It's something I'm gonna have to address with a lot of attorneys, and I know this is not typically. I've not had this conversation with you, so I know that this is not your pattern, but just something that I am concerned with, and I'm gonna start voicing it every time I see it. So hopefully we can curb that and not become a habit. Because I think that we need to move these cases along a little bit quicker. I think the alleged victims, the state, and the defendants, need that. So the court's going to grant an additional pretrial. Are you available on December 15th? That's a Thursday. We could do December 1st, 13th, or 15th. 15th is a lighter day.
Would it be a morning docket on the 15th?
It would be.
I think I just set something for that day. And I will be here already on the first, well, I was going to be here already on the first for a case that I wanted to address with, after I was done with this. So we can go ahead and set it for the first.
All right, court sets Mr. Cheatham for pretrial December 1st. That'll be at 9 a.m. And right now, Mr. Cheatham, it looks like it's scheduled to be across the street in the Justice of the Peace Precinct 2 building. It's in the courthouse annex, 2 blocks north of here. Okay. And also I showed that Mr. Cheatham failed to report in September. Mr. Waddell, have you met with Mr. Cheatham this morning?
Not yet.
All right, so Mr. Cheatham, I'm going to order that you meet with Mr. Waddell and that you not leave until I give you permission to do that. And then Mr. Waddell, let me know if there's any concerns that you have after meeting with Mr. Cheatham. Okay. All right, so I'll recall the case. If Mr. Waddell says you're free to go, then you're free to go. Okay, if he says you're going to need to see the judge, then we'll come back and I'll recall your case. Okay. This is on. Sure, yes. Here, I don't, this is, are they still here?
Yes.
Yeah, I only get new ones, but that doesn't look very clean. I mean, if an officer, somebody's relying on this, I'm not sure if they're going to get to tell them that, so.
My apologies.
It's okay. No, I told him to get you, I told him to get the patty this. Okay, so they're probably out there.
Okay.
All right, so y'all can have a seat, go outside and wait for Mr. Waddell, and then I'll recall your case, okay?
I do have one other thing I'd like to address with the court.
Yes.
The case I have set on December 1st is Christopher Dawson. The last time we were here, I urged a motion to withdraw on that case. And he said that he would try to get us paid. No payments have been made since that last day. I'd like to re-urge the motion to withdraw so that I can contact him and get him some time to try to come up with make the hire and return.
We're scheduled for the first.
We are scheduled for the first try.
We'll have to do that on the first, when he's here.
I understand.
So that he has a chance to be heard on that. That way he can object, or he claims that he has paid or something like that.
Thank you, Your Honor.
You're welcome.
Am I excused or anyway?
You're excused. You're welcome to stay with him if you want. If they come back in and they've got concerns, I may drug testing. His bond may be subject to revocation today. I don't know. So probably best stick around.
I don't vote on me.
Screaming, you ready?
I am ready, Judge.
Right, we got that one today, Mike Roberts.
Yes, sir. It's just right outside the door.
Can't go to bring her in. CR 22-224-225, state versus Monica Rochelle Roberts, and Miss Roberts is set for pre-trial today, Mr. Green.
Yes, Judge.
Any contested pre-trial motions?
Judge, I do have a motion to suppress that file that we'll be setting for.
All right, court will set Miss Roberts for evidentiary hearing. You want that sooner or later? We could do it on the 29th. 1, 2, or 2 weeks.
Judge, I would prefer later than that.
Later is gonna be January.
That's fine, Judge.
All right, court's gonna set Miss Roberts' motion to suppress, and you said that is filed and served on the state.
Yeah, I filed it last Thursday, 7 days ago.
All right, court will set Miss Roberts for January 26th. That'll be at 9 AM. I would plan on being here in this courtroom, subject to change, but I would report here. That's it, January 26th. Not at 9 AM.
This should be-
Yes, yes, pretty good. You can just start right here.
I did actually, if I could be excused, then
I'm not sure that you can,
Okay.
even if you didn't. Mr. Manning, you ready?
It's a direct recess.
Who do you like first?
So we can get Mr. Jason Barnes.
Jason Lee Barnes, CR 22-201. All right, Mr. Barnes is set for pre-trial.
Yes, Judge. We are in the process of negotiating with the state. I have received a HIPAA release that provides mitigating evidence to the state, but not being to the back. We requested additional resets on the trial.
Any objection from the state?
No, Your Honor.
Do you know that how long you may need? You think 30 days is enough?
Judge, this is the first time I've done that is post-COVID getting records, so I'm going to do wait time. What's your 30-day setting?
For you, it'd be the 15th. It's a Thursday. It'd be either the 1st or the 15th. Probably more time, but better.
Judge, the picture may be pushing it, but if we want to reset that,
We get pushed to January 5th. The Thursday.
let's do the fifth, Judge.
All right, Mr. Barnes, you're set for pre-trial hearing on January 5th of next year. That will be at 9 AM. And not sure where we're gonna be, Mr. Manning. Just plan on being somewhere in this building. All right, let's report back here.
We got that. Not yet. They're also ready on this Brittany Turner.
Brittany Turner. CR 21-400.
Judge, this is the one we're resetting it for a review of CPS records. I am deep in 2,500 pages of redacted CPS records, and I have not, unfortunately, able to get through all this at this time. I requested reset so okay, my deals to continue to review those records.
The objection.
No, Your Honor.
All right, court will reset Ms. Turner for January 5th. For pretrial and status of CPS records review.
Judge, I have paperwork on Mr. Hoover. We're working on, and we're waiting on conditions of probation for Ms. Perez. Oh, Mr. McGinnis.
You ready for Mr. McKibben? CR 22-00222. State versus Travis Flynn McKibben.
Yes, Judge, we have received a new offer today that my client wishes to accept. We request that he be set for January for a.
Separate time.
Yes, sir.
Probation.
It'll be for time.
Is that jail time or TDC time?
It'll be city jail.
State jail. Any objection from state?
No, Your Honor, that was our agreement.
No waiver of jury trial, just set for plea 60 days out.
It was not part of our agreement. The state's not opposed to doing that. The court, that would make the court.
Judge, Mr. McKibben showed up faithfully to all his court settings. He kept his meetings with me. I don't anticipate that being a problem.
All right, court will set Mr. McKibben then for plea before the court on January 5th. That will be at 9 AM, Mr. McKibben. I'm sorry, Mr. McKibben, so that's gonna be state jail time, so let's set that at 1:30 and we'll have him report to the jail. So that's it. Yes.
Judge, like I said, I have paperwork on the rest, and I will see if I can locate Mr. Collins and Mr. King as well.
Okay, thank you. Mr. Warner, are you ready?
Yes, Your Honor, on Atlanta Calder.
Do you have any info on Ms. Calder?
I do. I have not independently verified it. She contacted my office, I believe on the 8th, indicated she was in the hospital. And my office said you need to have something faxed to our office indicating, so there is something faxed. I just read it this morning, so I haven't called to verify it. Can I approach and show it to you?
This is for the record, call number CR 22-3 and CR 21-322.
I know the first thing you'll say is that's not her name, but that is a previous name or a current name for her. So.
Can you provide a copy of that to Ms. Tablingham? And
Yes.
I'll have her call and verify. And so what I'll do is I'll take a nice eye under advisement.
Okay.
Any confirmation of that.
Okay, do you want me to get a reset date or just wait to see?
No, let's go ahead and reset
Yes,
it. And I'm resetting to December 1st, 13th, and 15th.
I picked one of those yesterday. Let me see which one it was. I believe it was the 13th. I'm supposed to be in jury trial in Cherokee County starting that Monday, but I'll just let the court and state know for some reason it doesn't go, or if it does go, that's okay.
So we were set a date for a drug test confirmation.
That's correct.
What was the setting before that? You recall? Retrial.
It was, I believe it was my first appearance with her after subbing in, Judge. And the state and I have made substantial progress towards resolution that involves outpatient rehab. And the last time I spoke with my client, she was trying to secure proof that she would then accept it for outpatient rehab program, the addition of probation. So I think it was a little long in the tooth, but not for me. And we're really close to getting it resolved.
Judge, it was set for docket calls and a plea, then Mr. Weiner subbed in. We've had one free trial and then today's status.
Show that we're already set on the first for docket call.
I think it was set for docket call and additional because there was some question about a drug test last time, we set an additional setting.
And I'm fine, leaving it on the first, if that's what the board would like to do.
Reset it, and it's already been set.
Yeah, she's already signed indicating that she knows that to be here on 12/1 if not, so we'll just leave it on for.
Now, I want to be clear, I'm not sure if I remember telling her, because when she came back, we said we want to send out the confirmation, I think I told her that the only date that matters at this point is, you know, this date for this day. I can't remember if I gave her a reset for the first or not, Judge, just in all honesty. I know I filled one out initially.
This is not her signature here on the,
I'm sure it is.
I mean, on the appearance, she's acknowledging that the next court date is 12/1.
Okay.
You know,
Sure. I just, there may be some confusion because after we had done that, we set this next one, but as long as she has the notice of that, and I think, you know, she's received notice. So I was just trying to be cautious, Judge.
yeah, let's leave it set for 12/1, because that's the last thing that she's acknowledged.
Just leave it there.
You know, there's two reset notices, one for today and then one for first.
Yes, sir.
So we'll just leave it at that, and then we'll see where she's at in the hospital.
Okay. And I'll run this upstairs to your board coordinator.
Thank you.
That's all I have. Excuse me. Thanks, Judge.
Sir, appreciate that. This will be better. No question. Okay. Mr. Bryce. Mr. Bryson. I'm sorry, I keep saying that. Mr. Carroll. Bryce Carroll. It's a sanctions court. It's a sanctions court hearing. I'll bring it.
He's here.
Yeah, I think I saw him. All right, Mr. Booker, CR 22-239. All right, Mr. Booker, we are set for pre-trial today. Do you have any contested pre-trial motion that you filed?
No, sir. It is my understanding.
Sorry, I can't.
It was my understanding it's gonna be a relevant penalty.
No, sorry, I can't understand what you're saying.
It was my understanding that we supposed to have a relevant hearing on the dismissal of the council.
I think we've already gone. through that,
Right, I
right?
thought we did that in JD.
Yeah, I thought you did dismiss it, but you said that you had to go on record. With it, but I haven't filed any filed motion. Because you also recommended that this attorney trial itself.
Yes, sir. So, Judge, I will confirm for the record, Mr. Booker contacted our office to set up that appointment to come in and view his discovery on the 26th. However, the number that he provided for us, we couldn't get it to work. I tried calling Mr. Booker 4 times and it never went through. So we will get with him today and make sure we have a good cell phone number to contact him, but he has not seen discovery. Additionally, Your Honor, there's one more piece of evidence that we're waiting on a subpoena return for. And so states fully agreeable to another pretrial setting, where we can get Mr. Booker in to view all of that.
Okay, so let's make the record clear, Mr. Booker, you appeared in the Justice of the Peace Court Precinct 3 for our court, right? With no hearing in their court, we were just physically using their courtroom. And I admonished you with the Feretta warnings regarding waiver of court-appointed counsel. I made findings, we went through that on the record. You indicated you wanted to represent yourself, that you understood the dangers, the inherent risks. We talked about your previous experience. We talked about the fact that you would not be given special consideration because of your lack of legal training, lack of legal experience, that you have no right to stand by counsel. We did all of that previously. And so that's behind us.
So I would like to take this notice of respect. The strictness is in the case of irregularity.
Okay, well, those would have to be brought to the court's attention by pretrial motion and then provided to the state so that they could have notice, and then we would schedule for a hearing where we'd sit down and you would have an opportunity to present that to the court. That would have to have been done prior to today, so.
I have the most regret that I just had a file.
So what we're gonna do, Mr. Booker, is I'm gonna reset the case for pretrial to allow you to meet with the district attorney's office to review the evidence. And then this date that I'm about to give you, any pretrial motions must be filed in accordance with the Code of Criminal Procedure at least 7 days prior to that date. That's to allow the court to receive those and the state to have notice of them. And then on that date, we can set it for another date that's going to be where we have time to actually sit down and go through the merit of your motion, consider any evidence, consider any testimony. Okay. All right. So let's reset. Today is November 10th. I'm going to reset you to December 15th. That's going to give you more than 30 days to have time to go meet with the DA's office and then follow your motion. Okay. All right. So hang on right there. Notice the setting.
I'll try that and we'll get it that one.
All right, Mr. Booker, this is your notice of appearance. This says we're coming back for pre-trial on December 15th at 9 a.m. in this county courtroom. You'll sign that. I'll give you a copy for your records. All right, here you go. You too. All right, Mr. Carroll. Come on up. This is a sanctions court hearing in cause number CR 21-208. All right, Mr. Carroll, I see here we got several things for you to do. The last time we met in court, told you you had to do 4 days in jail, and you did that. You served your time, right? I told you to pay $85 to probation. You paid $530 in October, right? Good. I show that I ordered you to pay $85 to the court for your collections. Hmm.
I still haven't done that.
I know you should have done that one. 10 hours community service, didn't do that, and your substance abuse evaluation. Okay, so let's talk about the money real quick. So the order was to pay $85 for probation, and you paid over 500. While that's good, you should have taken 85 of that and done what with it? Paid your fines and court costs and those things. That would have been one less thing you didn't do, right? So think through that next time. If you want to pay ahead, that's good, but make sure you're paying every requirement that don't put it all on one and not pay the other, okay? So I'm not gonna hold that against you because you have paid more than you ordered to do in probation, but we do have to get money paid here. You understand that these are different entities. Probation, you have to pay for your supervision, your drug test, those things. Over here, you're paying towards your fine, court costs, reimbursements, those things, okay? So tell me why you didn't do your community service.
I just had that. I'm trying to find like a schedule, see where I can go, like maybe one whole week. I just had that. So
Okay, and what about your substance abuse evaluation?
I honestly thought that the only thing and the substance abuse was like the same. So I don't know. I just got to contact that.
Okay. So to me, it looks like you started trying, you started moving in the right direction. All right, so I'm gonna give you the benefit of the doubt. And I'm gonna give you another opportunity. So I'm gonna reset you to December 15th. Okay. And on December 15th, when you come in, I expect that you will have paid. Can I get a notice of setting? Deputy ever? Can I get a notice of setting? I'm gonna write this down for you, but you have to pay $85 to your probation. $85 to your collections, right? So you're behind on that. It'd probably be wise to go ahead and pay a little bit more on your court collections since you didn't pay last time. You've got to work 15 hours community service, okay? Because you didn't do 10 last time. I really should say 20. I should really say 20. I'm gonna say 15, okay? And you've got to complete your substance abuse evaluation. If you don't have those things done on the 15th, our conversation is gonna be a lot different. Okay. And so I want you to tell me, because I told you at the last setting when you were here, I told you what the purpose of sanctions court was. Can you tell me back in your own words what the purpose of sanctions court is, why I'm bringing you in here, I'm telling you to do these things?
Basically, that's like my citizen.
Hmm?
Basically, that's the system.
What else? What else? Keep you out of where? Keep you out of prison. You're not looking at jail, you're looking at prison. Big difference. You're looking at 2 to 20 on a deferred. Keeping you out of prison, keeping you on probation. All right, Mr. Carroll. I've written these things down here. I'm gonna give you a copy of this. I expect you to get on this immediately. Don't wait till the last minute. Okay? You wait till the last minute and you don't get these things done, you're gonna end up going back to jail the next time I see you. Okay? I'm gonna give you this. You're gonna check these things off as you do them. Start early. Okay? All right. So there's a notice of appearance saying you're gonna come back on December 15th. We're gonna be here in this courtroom. You're gonna sign right there and I'm gonna give you a yellow copy. Alright, good to go. That's why I don't want this. That way I don't have to keep it in my stuff. Dwight, are you ready?
Yes, Your Honor. On the Highland Rock Stroke Athena.
All right, CR 2141. The state of Texas versus Ivan Rocco Garcias on motion to adjudicate. Go ahead, Mr. White.
That's correct, Your Honor. I have been in contact with this attorney's office and I believe that we have agreed that we can do a reset till after January. There is a possibility that this could involve prison time. And I don't believe the state has any objection to that.
So after January, so like February?
Well, I guess after January 1st, well, after Christmas.
Judge, if we could set up for the contested docket in January, we will be able to either have it resolved that day, or we can go to contested hearing. That would be our standard procedure in any regard. So I think that would be the most logical way to proceed.
That council approach. All right, the court's going to take Mr. White's request under advisement for setting this case for motion to adjudicate on January, I believe that's 26th. January 26th. At this time, Mr. Rostro, I'm going to ask that the pre-trial release administer a drug test to you. Okay. So go ahead and just have a seat right there in the back, and then they'll come in here, they'll get you. And then they'll drug test you, and then I'll recall your case, okay? All right, Mr. Watkins. Right, so Ms. McGinnis, Mr. Sanders, Mr. Sanders is not here yet. He's indicated to us that he's in another court and he's coming this way. And he told us that he was going to be late. He wanted me to let you know in case you weren't. Okay, he's on his way. Yes, John Davis. John Robert Davis. CR 2135. All right, Mr. Davis, the state has filed a motion to adjudicate your guilt and revoke your community supervision. Are you going to be hiring an attorney to represent you? You are going to hire an attorney? So if I reset your case for about 30 days or so, do you think that'd give you enough time to hire a lawyer? Okay. I'm going to do that. You understand that you're still on probation. Even though they filed their motion, that doesn't mean that you don't report and drug test and do those things. The fact of the matter is that if you quit reporting and you quit complying, the state would be in a position to amend their motion to add more allegations to you. Okay, so despite that they filed a motion, you still need to report. Okay, so what we're going to do, Mr. Davis, is I'm going to reset you until Tuesday. I'm sorry, we're going to do Thursday, December 15th. And that will be at 9 a.m. And we'll be back here in this courtroom. Okay. And so Deputy Everett's going to have you fill out this appearance form, just saying that you were here today and we're resetting your case. Did you write on there to hire a attorney? Down there on the bottom where it says like status or something or other, check that off and write to hire attorney. And Mr. Davis, if you're unable to hire an attorney and you think that you meet the indigency requirements, and if you end up wanting to request a court-appointed attorney, you need to do that before you come back to court. Okay, so if you go to hire an attorney, you're not able to get that done, and you think that you meet the poverty level, then call my coordinator and go through that process, fill out that paperwork, so we can get that stuff handled before we come back to court to say time. Okay, all right, you're free to go. All right, Jordan Patillo, CR 22193. All right, Mr. Patillo, I reset your arraignment at our last hearing to give you time to hire an attorney. Did you hire an attorney? Okay, so you haven't hired an attorney yet? Who's the attorney that you are retaining? Yeah, absolutely.
Everybody's looking, I can shoot your signature on this. We issued a failure to appear on this defendant. He's been in the Smith County Jail since long before this date, so we'd like to release our hold. Apparently, he's still, his bondsman will be on his bond as long as we take care of this. And then he's been held in Smith County and they're not releasing him, so we don't have to pick him up. We'll just reset him. Thank you, Judge.
He's
not on our bond today.
Jonathan Shelton.
Johnny Arthur.
Okay, I knew I saw it. John King, but
Yeah, it's a different, one. Different one. Thank you, Your Honor.
Once we get going.
You're fine.
Desmond Cooks.
Desmond Cooks. Desmond Cooks.
Yes, sir.
And where is Mr. Cooks located?
Dallas, Texas.
Dallas. And how much have you paid Mr. Cooks?
2,500 so far.
Say it again.
2,500 so far.
2,500. How much does he ask for?
6,000.
Okay. All right, Mr. Patillo, I can't set you out for months at a time until you get up all your money. So the best I can do for you is I'm going to reset you until December 1st. That's only a few weeks. Okay. 1, 2, 3. That's 3 weeks from today. So you either need to go have Mr. Cooks with you that day or get your money back and hire another attorney that can be here on that day. Okay. So we got a form here, appearance form saying that you're here. We're resetting. Put arraignments and then go down to other input to hire. Let me write in there also. Charge me. All right, so one last thing, Mr. Patillo. When you were arrested on this charge, you were not arrested in Bank County, were you? Okay, so when you were arrested in the other county, your fingerprints, when you were processed, they were not sent back here to Van Zandt County, so Van Zandt County has not been able to complete their records reporting of you. So I've got an order here called a TRN processing order. And what this is it's an order that tells the sheriff's office to bring you in there, get your digital fingerprints and let you go. Okay, that's going to allow them to get your fingerprints so they can report it to the state, so they can be in compliance with the law. Okay, so I'm going to give you this. And I'm going to order you, when you leave here today, I want you to go right out to the sheriff's office. It's here on Highway 64 going west, like going back towards Dallas. It's only about a mile away. It's on your right. It's a brand new gray building. Okay, before you get too far out of town, you'll see it on your right after you pass the gas station. Take this order, go in there, tell them who you are, show them this order. They're going to bring you back. They're not going to change you out. They're not going to put you in the cell. They're going to bring you back. They're going to fingerprint you, and then they're going to let you go. It may take a little bit of time, so be patient with them. Okay. All right. All right. All right, we'll see you back on 12/1.
All right.
Busy man this morning, aren't you?
Yes, sir.
So Wyatt, are you ready? Okay, I didn't know if you were or not, so. Why didn't you go deep in thought? Oh, well, I'm always deep in thought. Who you ready on?
Let's call Ms. Robinson first.
Mary Lynn Robinson, CR 22194. Mr. Wyatt, do you need that chair? Oh. She's gonna go that way. Sure. You can go this way. All right, Ms. Robinson is set for pre-trial today.
Yes, sir, she is. So through my investigation in this case, Your Honor, I came into some information through another case that I'm handling that is going to possibly affect Ms. Robinson's case. I talked with Mr. Woodwide about it. More about it being more than 2 quick trials. I'm going to have to ask the court for the burden. This is something that may take me a minute to a little longer than usual because of the nature of the charge and the complexity. I said the complexity, actually. There were several witnesses, and I'm going to have to look into some things, so I'm going to have a pre-trial.
States unopposed, we've had this discussion.
Okay. There being no objection, the court will grant Ms. Robinson an additional pre-trial. July, December 15th, would that work? All right, court sets Ms. Robinson then for December 15th, that'll be at 9 AM, and we'll be back in this courtroom, Ms. Robinson. Same place we are today. All right, and Ms. Robinson, I need you to meet with Mr. Waddell here before you leave. Have you gone over your condition? Has she gone over her conditions of pretrial release yet, Mr. Waddell?
We're working on it.
Okay, so you've already started that process?
Yes.
Okay, meet with Mr. Waddell and you'll fill out your paperwork, your pretrial release paperwork, and you'll be free to go, okay? Who do you like next? Mr. Waddell?
This way.
Sandra Gail Fletcher, CR 22-272. Ms. Fletcher is set for pretrial.
Your Honor, we don't have any contested motions on this. By the court's pretrial order and ask the court to move this over to the call.
All right, court will set you up that same December 15th, Mr. White.
Yes, sir.
All right, court sets Ms. Fletcher for docket call on December 15th. Here in this courtroom at 9 AM. Has Ms. Fletcher received her conditions of pretrial release, Mr. White? Do you know?
I am not sure.
Okay, so Ms. Fletcher, once you sign that form with Mr. White and you get your yellow copy, then Officer Matura here to your left, if she's still over there, will tell you the next step. We're gonna have conditions of pretrial release that we need you to sign. These are gonna be things that you have to comply with while you're on pretrial release, while you're on bail. Okay.
Good.
Joshua Clay Martin, CR 22-278. Martin is set for pretrial.
Your Honor, we don't have any contested motions on this. We just ask the court to go over the call. Court pretrial, staying pretrial.
All right, court will set Mr. Martin for docket call on December 15th at 9 AM in this courtroom. And Mr. Martin, have you signed your conditions of pretrial release yet?
Yes.
You have, okay. So if you've already signed those and received those, then you're free to go.
Mr. Valderrama.
George Valderrama, CR 22-256. Mr. Valderrama also set for pretrial.
Your Honor, we're having contested motions at this time. We're going to ask the court to use over the docket.
All right, court sets Mr. Valderrama for docket call December 15th at 9 AM in this courtroom. Mr. Valderrama, have you signed your conditions of pretrial release? Not yet, okay. So once you sign and get this yellow copy, then Officer Matura here will direct you. We're gonna have conditions of pretrial release. These are conditions that the court puts on you that you must comply with while you're pending trial in this case or resolution. And a violation of those could mean that the court could revoke your bail and put you back in jail. They're gonna be standard things, report, drug tests, no new offense, things like that, okay? So. Yes.
Your Honor, we have Mr. McGinnis.
Obed, is it Mingistu or Mingistu? Mingistu. All right, I'm sorry. CR 22-190. Go ahead.
He knows my East Texas accent. I keep that leave there. Just keep it out of my mouth. Your Honor,
we were set for a plea. We came into some information that the alleged victim may be deceased in this. I made Mr. Woodward aware of that. He obviously didn't know that. The state had told him that, and he didn't know. We knew that the alleged victim was possibly killed. I just need very short, he said, to check on that. It should take me very long. I will note to the court, I had checked this numerous times prior, so this isn't something that was, you know, given what I knew, I just wanted to point out, I wasn't being there or anything like that. I just couldn't find it. And my conversation with the client, he made me aware of that, and so we're going to reach out to the person who told me and see, so I don't be very long. If the person's still alive, obviously, we'll make our decision. I imagine if the alleged victim is deceased, the state, Mr. Woodlock indicated, he's back in the situation.
And come back on the 22nd.
That's fine.
All right, Mr. McGinnis, the court will set you for status on plea on November 22nd. That'll be at 9 AM, and we'll be in that courtroom across the street in that Justice Square. I'm not sure if you've been in there or not, but 2 blocks away.
Yeah, your time maybe parking over there. But Your Honor,
11/22, 9 AM. All right, free to go.
Your Honor, I have a one case set this afternoon. It's going to be an amendment to probation to do for Mr. Rizzo. He's reporting obviously to the jail that he's going to be doing safety.
You said safety.
Yes, sir.
All right.
Am I free to go?
Let's have you drug tested with probation, then you.
I'm not doing that.
Have a good one. All right, Ms. Blaylock will be at 11. Is Miss Michelle Blaylock here? I think she's due here till 11. So Mr. Manning is still working on potentially Collins. French is not here. I think we have some information that her mother's in the hospital. Has he discussed that?
Mr. Manning brought both, apparently both Ms. French and her mother have been intermittently in the hospital. Between the two of them for the past month. Get too deep into that, Mr. Manning.
Yeah, no, that's fine.
We're not going to be opposed to a reset to allow her to get into compliance, which was our previous agreement, given her met her and her mother's medical situations.
Heather Hartman. What's your name? Jasmine.
That's Mr. Perez.
So we're on Mr. Sanders. Mr. Adams, and then to see if some of Mr. Manning people show up.
I believe Mr. Manning has a few places.
Okay. All right, we're just going to stand in recess for a little while, see if we have more people attend the court session. Rock, paper, scissors for who goes next?
Stay ready. I'm ready to be. Go ahead.
I got
You already know fun. All right. Ms. McGinnis. All right, this is cause numbers CR 21-153, 156, 179, all set for pre-trial.
That's great, Judge, and we don't have any pretrial issues, we can just set for not call.
All right, I'm setting things December 15th. Is that a good day for you?
Yes.
13th, is that Thursday?
Yeah.
Thursdays are generally better for you, right?
Yes, yeah.
All right, court sets Ms. McGinnis in for docket call on December 15th. That will be at 9 a.m. And Ms. McGinnis, we will be back in this one. Have you had an opportunity to sign your conditions of pretrial release? Have you gone over that with the pretrial release department? Okay, all right, so once you sign and get the yellow copy, you go to Officer Maturity here, she'll give you the paperwork. You're gonna have conditions that you're gonna have to comply with while you remain on bond in this case. You have to report to the pretrial release officer, you're gonna have to remain drug-free, drug test you, no new crimes, things of those nature. If you violate any of those terms, the court could revoke your bail, put you back in jail until your case is resolved, okay? All right, step outside and see the probation officers and they'll help you out.
Judge, I'm just putting this.
Yeah, just go up here. We'll go. Good seeing you.
Good to see you. I'll get it. Yeah.
All right, Mr. Manning, who would you like first?
Judge, if we want to, we can start with Miss Jasmine Perez.
Ms. Press. CR 22-247, Plea versus Jasmine Catherine Perez, separate pretrial.
Judge, we have a plea.
Okay.
Oh, I did not provide the paperwork to the state. Judge, we'll be resolving, Ms. Perez's felony as well as a misdemeanor TWI.
Judge, the misdemeanor was filed in this court.
It's filed where? Here. All right, Mr. Perez, if you will, raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you don't, you can lower your hand. Ms. Perez, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with any type of mental condition? Okay, anything else? Depression, anxiety, bipolar. And Ms. Perez, are you on any type of treatment, medications for those? Okay. Do you feel like you have a rational understanding of this proceeding today and what's going on in your case? You don't feel like there's anything that you're unclear about, is that right? Correct. Okay, and in this case, you are represented by Mr. Manning. And are you pleased with him being your lawyer? And you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything about this paperwork that you've read over and signed today that you do not understand? And where you have signed this paperwork, is that your true and correct signature and you only signed once you were confident and you knew what you were signing? Okay. All right, you have two charges. I'm going to go over the first charge, which is a state jail felony offense of possession of a controlled substance of penalty group 1 less than 1 grams. That carries a range of punishment, Ms. Perez. If you were to be convicted and sentenced, it carries a range of punishment of not less than 6 months in prison or more than the maximum 2 years in prison, and a possible fine not to exceed more than $10,000. You understand that range? And in CR 22-367, you are charged by information with a Class B misdemeanor offense of driving while intoxicated. A Class B misdemeanor in the state of Texas carries a range of punishment if you were to be tried and sentenced to a maximum not more than 180 days in jail, and a fine not to exceed $2,000. So those are the ranges of punishment. I see here that you want to enter into a plea agreement in each case. In your felony drug case of possession of controlled substance in penalty group 1 less than 1 gram, it appears that you want to plead guilty to that offense in exchange for the state's recommendation that your a finding of guilty deferred. That means that you not be convicted today, but rather you be placed on community supervision for a period of 2 years. That you be fined $2,400, that you pay $180 restitution, court costs of $290, and that you would reimburse Ramsey County $535. Is that your understanding of the plea agreement in that case?
Yes, sir.
And there's also a couple of other cases that the DA's office would be dismissing, another possession case, actually 2 more possession cases. Now, in the DWI case, it appears that you would plead guilty to that offense, and your punishment under the plea agreement would be 4 days confinement in the county jail. You would receive credit for 4 days of time already served. You would pay a $100 fine, $270 court cost, and $15 reimbursement. Are those the agreements that you expected to enter when you came to court today?
Yes.
Okay. Mr. Manning, do you believe Ms. Perez will be competent?
She is, Judge.
You've explained to her her rights as they pertain to each of these cases.
I have.
And have you also explained to her the advantages and disadvantages of a deferred adjudication plea in her felony case?
I have.
And do you believe that she understands them?
Yes.
All right, so Ms. Perez, you understand that if I approve these plea agreements today, one of them would be that on the felony case, you'd be placed on deferred community supervision. Do you understand that if you violate any of the conditions of your community supervision, the state can file a motion to bring you back to court? They could ask this court to convict you of that offense. They could ask this court to revoke your community supervision, and they could ask this court to send you to prison. And if they met their burden and they proved those things, the court could do those things to send you to prison, and the court would decide your punishment anywhere from the minimum 2 years. I'm sorry, the minimum 6 months all the way up to the maximum 2 years. Do you understand that? And you still wish to go forward? All right, so I'm going to ask you at this time, Ms. Perez, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram that occurred on October 30th, 2021? And how do you plead to driving while intoxicated, a Class B misdemeanor, on that same day?
Yes.
Are you pleading guilty to each one of these crimes because it's true that you are guilty of each one of these crimes? Has anyone threatened you, forced you, pressured you to plead guilty? Court will accept the defendant's plea of guilt in each cause respectively. Mr. Manning, any objection to the state's evidence?
No objection.
State's evidence is admitted in the stipulation in each case. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we have rest and close this time.
From the defense?
Press closed.
All right, court's going to review the evidence. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Ms. Perez of both of these offenses. The court will follow the plea agreement in each case. With regards to the possession of controlled substance penalty group 1 less than 1 gram, the court will defer a finding of guilt, place Ms. Perez on 2 years community supervision, order her to pay a $2,400 fine, $180 restitution. $290 court costs and $535 reimbursement fees. The court dismisses under section 1245. DA 2021-1388 and DA 2021-1389 with regards to cause number CR 22-367, driving while intoxicated. Court follows the plea agreement, convicts Ms. Perez of that offense, assesses her punishment at 4 days confinement in the county jail, gives her credit for 4 days time served towards that sentence, orders her to pay a $100 fine, $270 in court costs, and $15 in reimbursement fees. All right, Ms. Perez. To me, it looks like you have a drug problem. Would you agree? So what are you gonna do about that?
And it's not blood, I haven't really had this before.
Was it after this or before this?
Before that.
Before that, so that didn't work. You're lucky that several things haven't happened to you. You're lucky that you didn't kill yourself while you were driving while intoxicated. Or worse, kill somebody else. And rarely do I see someone possess meth, cocaine, and heroin all at the same time. That's rare. Do you know how many drug cases I see? A lot, more than I wish to see. And I think you may be the first one in all my years of doing this that I've seen all of those be together. That's very concerning to me. Okay. So now's the time to get help. You need to go to probation and you need to ask for help. And if you can't beat your drug addiction on your own, going through NA and things of that nature, then you need to talk to them about other resources they have. Okay, so Mr. Manning and the state are giving you an opportunity here to not be in prison right now. Okay, all right, do you have kids? No kids? You have a family?
My grandma.
They care about you? They love you? They want to see you off drug. They probably like you better when you're not dirty, right? They like you a lot better when you're clean. Okay, so I hope that those things stick in your mind and you do what it takes to stay clean, make yourself better. You know that this is an addiction you're going to live with the rest of your life, but you can control it. You can stay on top of it rather than letting it control you. Because if you let it control you, you're going to end up you're going to end up in prison. I don't know, have you ever been to prison? Have you ever been to long-term jail? It's not a good place to be. How old are you?
25.
25. You're a young lady, very young lady. Don't waste the rest of your life sitting in jail, sitting in prison, sitting in prison run rehabs. Okay? Do what you gotta do. Let the people, let the men and women at the probation department help you, okay? All right, Ms. Perez, you're hereby remanded to the custody of the Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you fingerprinted by Deputy Ever here, and then Officer Mature to tell you the next step, okay?
Judge, you ready on Mr. Hoover?
Mr. Hoover, Eric Ashley Hoover, CR 2268 for docket call.
Judge, we have reached an agreement in this case. And this was voted of not only the two cases that we filed with Mr. Hoover, but additional. Depending on who you're looking at, 8 to 9 cases that have been unfiled.
And for the court's information, of those 6 to 8 of them, the DA's office has never received. So it's been 6 months, so we are formally rejecting all those cases, even if we receive them at this point. As a part of this agreement, we are rejecting and not proceeding on those charges.
And Judge, you will see a formal rejection for the 6 that they did receive numbers on, but there's some additional ones. And then all still now the same June 27th date.
That is our agreement. We received PC affidavits on felonies. I believe there's like a evading arrest or something of that nature that we don't even have records of. That he was even, I think there's a jail book-in for him, but we never received PC affidavits or anything that indicate that they exist.
All right, this is State of Texas versus Eric Ashley Hoover, CR 22-68. Mr. Hoover, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Just make sure you speak up loudly and clearly for me so I can hear you, so my court reporter can type down what you're saying, okay? All right. Your name is Eric Ashley Hoover. Is that right?
Yeah.
And Mr. Hoover, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney? You feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything in this paperwork that you've read and signed today that you do not understand? So you got to speak up. I understand. Okay, it's very important. She's got to jot down what you say. Okay, you understand everything. Okay, and where you have signed in this paperwork, Mr. Hoover, you're telling me that this is your true and correct signature, and that you only signed these documents once you knew what you were signing.
Yes.
Okay, Mr. Manning, do you believe your client to be competent?
Yes, Judge.
And you've explained to him his rights that they pertain to this case?
I have.
And you believe that he understands those rights and the waivers that he's making today?
Judge, after extensive going over paperwork as well as this question, I believe he does.
All right, Mr. Hoover, I see here that you are charged by indictment with a state jail felony offense of illegal dumping greater than 200 pounds or 200 cubic feet. That is a state jail felony. If you were to be tried and convicted and sentenced, the range of punishment for your sentence would have to be somewhere between the minimum 6 months to the maximum 2 years in prison. You understand that range of punishment? Yes, sir. I see here that the plea agreement in the case is that you would plead guilty to this crime. And the state would recommend to the court that the court assess your punishment today at 2 years confined in the state jail, that maximum amount of time. But they're recommending that the court suspend the sentence today and place you on community supervision for 3 years. In addition, you would have to pay court costs and reimbursement fees. And they would be, as you heard them say, dismissing some other cases and rejecting other cases that haven't been filed. Is that your understanding of the plea agreement? And you understand that if you are placed on community supervision and later you violate, if it happens that you violate a term or condition of your community supervision, you understand the state could file a motion to revoke your community supervision and ask this court, upon them proving their case, to sentence you to the 2 years, which would be assessed today. Okay, understanding all that, do you still wish to go forward?
Yes.
Okay. All right, then the court would ask you at this time, Mr. Hoover, how do you plead to illegal dumping? Greater than 200 pounds or 200 cubic feet? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened you, Mr. Hoover, forced you, or made you feel like you had to plead guilty today?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection.
All right, states evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Judge, briefly, the state reached out. This is a game warden case that was on public land. We spoke to them about restitution. They are not seeking any restitution, Mr. Hoover, for the cleanup from the dumping of the trash. Beyond that, we'd ask that you call the plea agreement to rest closed this time.
Thank you, Mr. Woodlock. I was going to ask about that, so I appreciate it.
I figured.
Yeah. Anything further from the defense, Mr. Manning?
Nothing from the bench, Judge.
All right, the court's reviewed the evidence. I do find enough evidence to convict Mr. Hoover of this offense. The court will follow the plea agreement between the defendant and the state. Court hereby convicts Eric Ashley Hoover of illegal dumping, state jail felony. Court assesses punishment as 2 years confinement in the Texas Department of Criminal Justice State Jail Division. Court will suspend the sentence today and place Mr. Hoover on 3 years community supervision. Court orders him to pay a $290 court cost, $535 reimbursement fees, and the court dismisses cause number 2022-359 criminal trespass. The court acknowledges the notice of disposition on the rejected theft of material case from the DA's office.
6, Judge.
6 cases. All right, Mr. Hoover, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you go with Deputy Everett here to be fingerprinted. After that, you'll report to Officer Mature behind you, and she'll give you more information about probation.
Right.
I'm assuming that All right, Ms. Heath, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Your name is Jerry Ann Heath, is that correct?
Yes, sir.
And Ms. Heath, are you a United States citizen who reads, writes, no, yeah, let me finish. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed?
Bipolar, manic depression, anxiety, and.
Are you on medications or
Yes.
undergoing treatment for those? Okay, and when you say, mhm, you gotta
Yes,
say
sir.
yes or no. A court reporter has to actually type down what you say, not what your head does, okay? All right, and so do you feel like your medications that you're on today are helping you have a good understanding of what's going on in this case, your discussions with Mr. Manning?
Yes, sir.
Okay, good. And Mr. Manning, do you believe that he can be competent today?
She is very nervous, but she is competent. I had an opportunity to sit down and explain things to her. And she's asked questions that indicate that she understands what's going on, and what she's about to do.
You also talked to her about the advantages and disadvantages of a deferred adjudication plea.
I have to.
And y'all have specifically talked about Ms. Heath's right to an indictment in this case.
Yes, Judge, we discussed that as well. The way this case originally began was we waived indictment when she was in jail in order to get this case resolved, and then she was able to bond out. So that's how we get about it.
Ms. Heath, you understand that you're charged with a felony offense of forgery. And a person can only be brought to court for a felony accusation against them if the case goes to the grand jury and the grand jury returns an indictment. Basically, a certification of reviewing the evidence and saying that it's very likely or more likely than not likely that a person's committed a crime. And you understand your case has not gone to the grand jury.
Yes, sir.
And you understand that you have that right. You can tell Mr. Manning, you can tell me, you don't want to go forward today. You can tell the state, take the case to the grand jury and see if they indict me. You understand that?
Yes, sir.
You also understand that the only person that can waive that indictment is you.
Yes, sir.
Mr. Manning can't do that, I can't do that, and the prosecutors can't do that. And you understand that. And today you're telling me, Judge, I want to waive my right to indictment and I want to allow the prosecutors to prosecute me on this case without going to the grand jury.
Yes, sir.
And has anyone threatened you, forced you, pressured you to make you feel like you had to give up that right?
No.
All right, the court will find that Ms. Heath has been admonished as to her right to indictment in this case, as intentionally, knowingly, and voluntarily waived that right. The court will approve the waiver of indictment. Ms. Heath, I also see here that you want to enter into a plea agreement with the state wherein you would plead guilty to the third-degree felony charge of forgery. A third-degree felony in the state of Texas has a potential punishment range of not less than 2 years in prison, up to a maximum 10 years in prison, and a possible fine not to exceed $10,000. I see that the plea agreement in your case is you want to plead guilty to that crime, and the state would be recommending that the court not convict you today, but place you on community supervision for a period of 6 years. Or would also be ordering you to pay a fine, court costs, and dismissing some other cases, in addition to reimbursement fees. Do you understand that if the court approves this plea agreement and places you on deferred community supervision, if you violate the terms and conditions of your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you of this offense, and the court could consider any evidence that the state brought in that hearing. If the court finds that you have violated your community supervision conditions, the court could adjudicate you, convict you, revoke your community supervision, and then the court could sentence you to prison anywhere within that minimum to 2, all the way up to the maximum of 10. You understand that?
Yes, sir.
Understanding all that, you still wish to go forward?
Yes, sir.
Okay. All right, Ms. Heath, at this time, I'm going to ask you, how do you plead to forgery of a governmental or national instrument, money, or security?
I plead guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty?
No.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
So,
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest assured.
Anything further from the defense?
Just briefly, Judge, Ms. Heath, as you all know, was found indigent when she was appointed counsel. We would ask that my attorney's fees be waived on this particular case. Ms. Heath is on a fixed income and recently has run into some difficulty with both of her vehicles, and she's unable to, at this point, and we'd ask that we waive those fees, that she starts off not being too far behind. She does have, my understanding is at this point, she has paid into pretrial release for attorney's fees and that other thing. We ask that no further attorney's fees get set as a part of the relation.
All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Ms. Heath of this offense. Court will follow the plea agreements reached with the state. Court hereby defers a finding of guilt on the third-degree felony offense charge of forgery of a governmental national instrument, money, or security. The court places Ms. Heath on 6 years recent revision, orders her to pay a $2,500 fine, $290 court costs. The court will dismiss under section 1245 DA 2022-0810 forgery and DA 2022-0811 failure to ID by giving false or fictitious information. The court, in considering the defendant's request to have the reimbursement fees for legal counsel waived, court will find that Ms. Heath was found to be indigent by the court. Court did appoint counsel to satisfy the Sixth Amendment of the United States Constitution. Court will find that Ms. Heath was found indigent, but with the ability to reimburse the county. Court will find that by the virtue of Ms. Heath making some payments towards her pretrial release fees for attorney fees, that she does have the ability to reimburse the Van Zandt County taxpayers for the indigent defense costs that were expended on her behalf. So the court's going to deny the request to waive the attorney fees and reimbursement fees. So Ms. Heath, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come up here with Deputy Everett. You're going to take your fingerprint, and then you'll talk with the probation officer, and they will give you some steps for the
Okay, yes, sir.
following out your probation.
Right.
We want next, Mr. Moon.
Through you, Mr. Pepper.
CR 20-371, CR 22-342, State versus Hunter Tapper, show that we're set for arraignment on the sexual assault of a child case, and I think we have a hearing set on the motion to revoke. I recall that Mr. Tapper at the last hearing, Mr. Manning, you were appointed under his finding of indigency. This is your first appearance with him in court, is that correct?
That's correct.
Are you ready for arraignment?
Yes, Judge. Mr. Hunter, sorry, Mr. Tapper's name is spelled correctly. Township charged against as well as a bench punishment. At this time, I plead not guilty and request to be set up pre-trial. Additionally, Judge, I believe I'm still waiting on some discovery for Mr. Tapper's case, as well as the motion to revoke. And so once I get that, I'll sit down and discuss our options for pre-trial.
Do you know what it is that you're lacking?
Judge, off the top of my head, I don't. I know I have read some reports. I believe that I was still waiting to view the CAC, or if there's a CAC number, I'm not sure of that. But I have not seen a CAC or any other forensic work on that case.
State, what are you looking at that?
Judge, I'm looking, I believe there are a few items that were not shared in the discovery portal that I'm sharing at this time. And there should be discs. We'll make sure those are available. And then there is a CAC interview. It is on discs. So Mr. Manning will have to make arrangements. You can watch that in our office.
All right, let me set you out a little further than 12:15, so you got time to make arrangements to watch the CAC and all your questions.
Yes, Judge, and also it is time to negotiate. I haven't spoken to the state yet about Mr. Tapper's situation. So if we can have a little bit longer recess, that would be appreciated.
All right, court will set, are you available on January 5th?
Yes, Judge.
All right, court will set Mr. Tapper for pretrial hearing and motion to revoke on January 5th. And that'll be at 9 a.m.
Streaming here in videos have been available in our office since 10:31, so they're ready to pick up.
All right, Mr. Tapper, remember, you're still on probation. Still got to report, still got to comply. And I would warn you that if you commit any new violations, violating your terms and conditions, the state is within their rights to amend their motion to adjudicate and allege new allegations. That would certainly frustrate your case, and I'm sure it would frustrate Mr. Manning's ability to be able to help you. That's okay.
Judge, the last thing I have, has yet to be taken care of Mrs. French's case. Judge, if I may, Mrs. French reached out to me on Friday, with her last, stint.
And let me say, I've reviewed the information you provided to Ms. Abraham, Mr. Woodwhack, and I discussed it a little bit while you were attending to your client. So court is satisfied that she has medical issues that prevents her from being here today. So, and also that Ms. French is resolving the last few hours of her community service. So I'm going to go ahead and reset her for January. We'll set her January 5th.
Excellent, Judge. And my other request, and I think this is the case, is if she does get her those hours completed, is the court okay with signing off on that without her?
If the probation department is in agreement, then yes. There's no other issues that they need to address in her motion. do you have any updates on your other clients who, well, were not present at the call of the doctor?
Judge, if I may, let me check my email. I had emailed Mr. Collins earlier in the week. To discuss his compliance. And preparation for the plea, and I have not received an email back from him. And
Heather
Hartman, my only time in contact with her was when she was in court last time. She had been in jail, bonded out. We had discussed some information briefly, but I have not heard or seen her since.
And spoke with mother. The number that I've been given was not the defendant's actual number. She didn't think anything important or whatever. She said she'd never been done. I told her she had court this week. And this person I talked to didn't respond very significant to say any cause of harm.
Judge, my understanding from my brief conversation with Ms. Hartman in court last time was that she does live in a state adjacent to, so what I'll do is when I get back to the office, I'll see if I can reach out and see if there's some explanation for her presence.
But Jonathan King,
Judge, my last contact with Mr. King was in custody. I was unaware that he had bonded out until we received the docket setting. Showing he was at 9 a.m. I have not had any contact, and I don't believe that we have a waiver on file. But if I do have a waiver on file, I'd ask the court to grant that. I don't see, and looking through, I don't see that I've filed anything. So maybe have an opportunity. I'm not sure if notice is provided once he left the jail. So if I can just have an opportunity to try to contact him this afternoon. Like I said last time I talked to him, he was in custody.
notice that we mailing notice to an address on 4908 in Ben Wheeler.
Did 29 or 8?
4908. And then sent notice to his bondsman also. So
Judge, I do know that if he was released, there's most likely a restraining order that would not have permitted him to go back to that address. So let me see. What if I find out if we can maybe hold off till this afternoon on this. Okay.
I'm gonna call his name this morning and then we can talk about it again this afternoon.
Absolutely, Judge.
Okay. All right. Thank you, sir. Mr. White, you ready? Right, this is cause number CR 20-141, state versus Ivan Roscoe Garcia. Mr. Waddell's understanding that Mr. Roscoe was negative on the quick test.
Yes, sir.
Okay. Any other concerns from pre-trial release?
No.
Okay. All right, then, having considered Mr. White's request, and there's no opposition from the state, court will set Mr. Roscoe for contested hearing on January 26th. That will be at 9 a.m. Not sure where we'll be, just check back in here at the courthouse. And we'll either have seen you notice earlier, we'll contact your bondsman will contact your attorney as well. You're good to go.
Thank you, sir.
I believe that does take care of everything I've got, Judge.
Thank you for sticking around. I appreciate it. Mr. Adams, you ready? Come on up, Blaylock. This files number CR 22-203, State versus Michelle Renee Blaylock for Docket. You.
That's, Mitch Adams, or Ms. Blaylock, and American folks. We've been in a plea agreement with the state and just taken to the court, the documents necessary to effectuate that, we're ready to proceed.
All right, thank you, sir. Ms. Blaylock, if you'll raise your right hand, ma'am, I'm going to place you under oath. Ma'am, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You can lower your hand. Your name is Michelle Renee Blaylock.
yes, sir.
And Ms. Blaylock, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
I'm not bipolar, PTSD, anxiety, and depression.
Are you currently on medication for those?
Yes,
Are you under a doctor's care?
yes, sir.
And do you feel like you have a rational understanding of the proceedings in this case?
Yes, sir.
And Mr. Mitch Adams is your attorney. Are you pleased with him as your lawyer?
Yes,
Feel like you had enough time to talk with him about your case and have all of your legal questions answered?
yes, sir.
Is there anything about the paperwork that you've read over and signed today with his assistance that you do not understand?
Yes.
Mr. Adams, do you believe your client to be competent today?
Yes, Judge. Ms. Blaylock and I have met several times. She's lucid, coherent, as anybody that I've ever known. She's legally.
Can you explain to her her legal rights as they pertain to this case?
That's correct, right?
And you believe she understands her rights and the waiver she's making today in this plea?
She does fully.
Ms. Blaylock, you are charged by indictment. You're charged by indictment with a state jail felony offense of possession of a controlled substance in felony group 1 less than 1 gram. The state alleged a few enhancements, and so the range of punishment, which is typically minimum 6 months in prison to a maximum of 2 years in prison, was potentially enhanceable up to a maximum of 20 years in prison. I see here today that there's an agreement in your case wherein you would plead guilty to that charge, and the state would be prosecuting you under section 1244A of the Texas Penal Code. What that means is if I approve this plea agreement, you will be convicted as a state jail felon today for that charge, but you will be punished as a class A misdemeanor with jail time that could not exceed 365 days of jail. That's the range of punishment. I see that the plea agreement is that the state's abandoning those enhancement paragraphs, that you would plead guilty to the offense, and they would be asking, the state would be asking the court to assess your punishment at 132 days confinement in the county jail, with the court giving you credit for 132 days time served. You would be ordered to pay a $1,500 fine, $290 court cost, restitution of $180, and reimbursement fees of $785. Is that the plea agreement as you understand it?
Yes,
And that's what you're asking the court to approve today?
yes, sir.
Are you able to make any payments today towards your fines and court costs?
Not, I don't get paid till tomorrow, so.
And how much are you planning to pay on this tomorrow?
And I'm trying to pay at least $100 a month.
All right, so I'm gonna ask you, Ms. Blaylock, how do you plead to possession of a controlled substance, penalty group 1 less than 1 gram? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anybody threatened you, forced you, pressured you to plead guilty?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Adams, any objection to the stipulation of evidence?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Sarah, we're
All right, court's going to review the evidence. And in the offense report, it says that Ms. Blaylock was also arrested for prohibited substance in a correctional facility. Is that being resolved?
Let me double check, Judge, I believe that case has already been rejected, but let me make sure. Yes, Your Honor, the prohibited substance was declined previously by our office.
All right, thank you. All right, court's reviewed the evidence, and I do find enough evidence to convict Ms. Blaylock of this offense. The court will follow the plea agreement she's reached with the state. Court hereby convicts her of possession of a controlled substance, penalty group 1 less 1 gram. State jail felony. Court assesses her punishment under section 1244A of the Texas Penal Code to 132 days confinement in Advancing County Jail. The court issues Ms. Blaylock credit for 132 days of time served. Court orders her to pay a $1,500 fine, $180 restitution, $785 reimbursement fees, and $290 court costs. Ms. Blaylock, you're hereby remanded to the custody of the Advancing County Sheriff so we can carry out the terms and conditions of the sentence. So you owe substantial amount of money here, over $2,000. So I'm gonna need you to meet up with the court compliance officer. She's ill today. She's not here. Next week, we'll close tomorrow. Next week, come up here and make your payment that you plan on making to the clerk. And then go down to the other end of the hall and meet with the court compliance officer. And let's set up a payment plan so that we know that you're taking care of your business. And if you don't do that, then the court's going to end up issuing a warrant for your arrest. We're going to kind of go through this whole process again for your files and case, okay? All right, come up here, deputy.
You're right.
Thank you, Mr. Adams.
Yes, sir, that'd be excused to over there.
Sure,
Sure.
sure. You get your,
If you must.
if you might, do you, get your other matter, you in Smith County, were you in Smith County or?
This morning,
Yeah.
I didn't have anything else going on, I just had everything else enough to put it to 11 o'clock, so that I wasn't spinning my wheels here for 2.5 hours later.
Yeah.
Not that I'm on meeting,
Yeah, I know you don't, I can tell.
that'll make some money.
I can tell you like me.
I love them.
Yeah, so let's call these names here.
You know.
On TV, yeah. Let's call Kevin Collins, Heather Hartman, Jonathan King. We'll go on with that.
What about Landon College?
Smith Calder is in the hospital, and so we went ahead and reset her to some other day. Looks like we set her 12-1. He was already set 12-1 afterwards.
Okay. Y'all gonna stay down here, right?
Thank you, Deputy Everett. All right, the court has called the following names at 9 AM. They were not present. Their names have all been called loudly, distinctly 3 times in the courthouse with no response. Kevin Latrell Collins, Heather Lee Hartman, Jonathan Cantrell King. Court will issue judgment with nice size and Kaylee Escapias. Court will not take them under advisement at this time, but will consider withdrawing them should Mr. Manning provide additional information as to their whereabouts or their impending arrival here in the great free state of Antigua.